Medicaid planning is a crucial process for many families in New York, especially when one spouse requires long-term care that can be financially draining. Spousal refusal is a strategic aspect of Medicaid planning in New York that enables a non-applicant spouse to legally decline the use of their financial resources for the Medicaid applicant spouse's care. This complex process can significantly impact your asset protection strategy. Spousal refusal. Definition and purpose. To qualify for Medicaid, individuals must adhere to specific income and asset limits. When evaluating eligibility, the combined assets and income of a married couple are considered, regardless of whether only one spouse requires care services. In the state of New York, the spouse who does not need care, often referred to as the community spouse, is allowed to retain a monthly income of approximately $3,853.50 and up to $154,140 of the couple's total assets. This is referred to as the Community Spouse Monthly Income Allowance, CSMIA. Eligibility requirements for spousal refusal. To utilize spousal refusal in New York, there are specific eligibility requirements that must be met. Marital relationship. Medicaid application. Formal refusal. Notification. Key considerations for spousal refusal in Long Island Medicaid planning. When engaging in Medicaid planning on Long Island, New York, a critical strategy that may come into play for married couples is spousal refusal. This legal maneuver can have significant implications for asset protection and long-term care planning. However, it must be approached with a clear understanding of New York Medicaid laws and the potential repercussions. Here are key considerations to keep in mind. Legal requirements and documentation for spousal refusal. Proper legal steps and documentation are vital for a spousal refusal to be recognized and effective. Formal written refusal. Disclosure to Medicaid. Consideration of subsequent legal actions. Updates to estate plans. Steps for implementing spousal refusal. To understand how spousal refusal works in the context of Medicaid applications, here is a breakdown of the necessary steps. Step 1. Asset transfers to comply with Medicaid limits. The initial step involves reallocating assets above Medicaid's threshold from the spouse seeking benefits, the applicant, to their partner, the non-applicant. This reallocation enables the applicant to fulfill Medicaid's asset criteria. Such transfers are exempt from Medicaid's 60-month look-back period, which typically imposes penalties for asset transfers below fair market value. Fortunately, asset transfers between spouses are not subject to these penalties. Step 2. Submission of a spousal refusal notice. The next step requires the non-applicant spouse to complete a formal declaration, known as a spousal refusal notice, indicating they will not contribute to the applicant's care costs. After submitting this notice to the Medicaid office, the applicant's eligibility will be evaluated as though they were unmarried. Consequently, the financial resources of the non-applicant spouse are disregarded in the eligibility assessment for the applicant spouse. Step 3. Filing a spousal refusal form during the Medicaid application. As part of the Medicaid application, the applicant must also submit a spousal refusal form. By executing this form, the non-applicant spouse effectively declines to provide financial support, and the state is then granted the right to pursue reimbursement from the non-applicant spouse for the cost of benefits provided to the applicant. This legal measure allows the state to recover funds spent on the applicant's care from the non-applicant spouse. Spousal refusal. Protecting assets in Medicaid cases. Spousal refusal is a technique used in New York to help protect assets in cases where one spouse requires Medicaid to help pay for long-term care costs. This strategy can be particularly complex when it involves significant assets like real estate and various financial accounts. Let's delve into how spousal refusal can affect these assets, and what must be considered under New York Medicaid law. Asset transfers and spousal refusal. When considering spousal refusal as a Medicaid planning tool, it's crucial to understand how asset transfers can impact eligibility. Exempt transfers. Timing. Documentation. Real estate considerations in spousal refusal. Real estate often represents a couple's most significant asset, and the treatment of real estate in Medicaid planning is particularly complex. Primary residence. Transfer of title. Estate recovery. Financial accounts and spousal refusal. The handling of financial accounts in spousal refusal requires careful planning. Separation of accounts. Account ownership. Disclosure. Estate recovery efforts post-spousal refusal. In New York, when a community spouse exercises spousal refusal, declining to make their income and assets available for the cost of long-term care for their spouse who is applying for Medicaid, the state has legal recourse to recover funds spent on the Medicaid beneficiary's care. This is because, under New York law, spouses are legally obligated to support each other. Here's how the process typically works. Assignment of rights. Claim against the community spouse. Litigation and settlement. Estate recovery. Implications of spousal refusal in Long Island Medicaid planning. In the context of Long Island Medicaid planning, spousal refusal has significant implications for couples facing the need for long-term care. While it offers a means to protect assets, it also intersects with long-term care services and coverage, estate planning, and the need for ongoing evaluation of the chosen strategy. Long Island residents need to consider these implications within the framework of New York Medicaid laws. Spousal refusal and estate planning considerations. When integrating spousal refusal into Medicaid planning in Long Island, it's crucial to consider how it will affect the couple's estate plan. Asset protection. Will and trusts. Tax implications. Future planning. Revisiting spousal refusal strategies. Spousal refusal is not a set-it-and-forget-it strategy. It requires ongoing attention and may need to be revisited due to changes in circumstances or law. Regular reviews. Changes in law. Health and financial changes. Secure your future with skilled legal assistance from Schlessel Law PLLC. Spousal refusal is more than just a Medicaid planning technique. It's a crucial decision that can protect your assets while ensuring your loved one receives the care they need. In New York, choosing this option requires a nuanced understanding of Medicaid laws. With Schlessel Law PLLC, our Long Island Medicaid planning attorneys are adept at guiding clients through the spousal refusal process. We can assist in protecting your financial well-being and providing clarity on the potential ramifications. Take the next step in securing your financial future. Contact Schlessel Law PLLC at 516-574-9630 for personalized assistance with the spousal refusal process. Our dedicated team is ready to help you make informed decisions that align with your Medicaid planning goals.